Good afternoon. Welcome back to Senate Education. Today is Wednesday, March 10th, 3:46 in the afternoon. We are back and going to continue our work by having a walkthrough of an amendment to S16, which is the school discipline bill. This is an amendment that Senators Balint and Hardy and others have come to me to talk a little bit about data collection and the need for greater data collection. I apologize, I must have missed the boat on this. I do remember hearing testimony around the collection of data and aggregating that data. Aggregating, is that the word I want here, Mr. Desmarais? Yeah. Yes, thank you.
Disaggregating, yeah.
Disaggregating, thank you, the data, yes. And so that is what this amendment does. And I will let colleagues, anyone who is interested in co-sponsoring this with Senators Hardy, Campion, and Balint, please feel free to do so. And with that, Mr. Desmarais, if you don't mind taking us through the amendment.
Sure. Do you want me to put this up?
Would you be so kind?
Sure, yeah. Jeannie, can I share the screen? Great, thank you. Let's see. Okay, for the record, Jim Desmarais, Ledge Council. We're walking through, nope, so we're not walking through that one. It's all right. Get rid of that one. S16. 1 second, please. Let me just pull this up again.
Is what's on the website the right draft, Jim?
It is. I just I had it open and it shut down, so I was trying to get it open again to share it with you.
Would you prefer, Jim, that we just use our iPads?
I don't prefer either. I have it right here.
Okay, great.
Let me just get this open. And then minimize that. Okay, and then oh shit. Okay. Here we go. Okay, here we go. So for the record, Jim Desmarais, Ledge Council, we're walking through an amendment on behalf of Senators Campion, Balint, Hardy, and Hooker to amend the report of your committee on S16. And what this does is it amends certain of the powers and duties of the task force. So it's striking out subsection D in its entirety and inserting this language here, beginning on line 7. So there are no changes until we hit the yellow highlighted parts. So all this is the same as in the your report, your amendment by the committee. But we go down to here, and now we get into some different language. So we're in the subdivision that has the task force compiling on a school district and approved independent school basis the available data and the data collection processes regarding suspensions and expulsions, and compiling additional data necessary to inform the work of the task force, including a number of things. So one was every 4, total number of instances of expulsions and suspensions in each grade, total number of students in each grade who were expelled or suspended, and the number of instances of expulsion or suspension or both for each student, duration, the infraction, and now with 5, we get into some new language. So 5 says now each instance of referral to enforcement authorities, the juvenile justice system, community justice center, state's attorney's offices, Department of Children and Families, or other juvenile justice related authority. And then 6 is new. It says each instance in which a civil, criminal, or juvenile citation was the consequence for a school related infraction. And 7, each instance in which an excluded student received re-educational services, as well as the duration of re-educational services per day, per week, and per month. And then F was there before, as to recommend changes to data collection. And G was there before, which is reviewing how other states address exclusionary discipline. And now 2 and 3 are new. So 2 is where we disaggregate data. So it says all data specified in subdivision 1E, and that's the entirety. So when we're saying 1E, we mean all this data here, 1, 2, 3, 4, 5, 6, all the way through here. So all that data shall be in disaggregated format by, at a minimum, the following subgroups and categories to the extent permitted by federal and state privacy laws, and to the extent information is available. So that would be people who are white, Black, Hispanic, American Indian, Alaska Native, Asian, Pacific Islander, Hawaiian Native, low income or reduced lunch, limited English proficient or English language learner, migrant status, students receiving special education services, students on IEPs or education plans under 504, gender, sexual orientation, foster care status, homeless status, and grade level. And then specified in that same division 1E shall be cross-tabulated by a minimum the following subgroups and categories to the extent permitted by federal and state privacy laws, and to the extent information is available. And that has to be done by school district, race, low income or free or reduced lunch, limited English proficient or English language learner, migrant status, students receiving special education services, students on a 504 plan, based on gender, sexual orientation, foster care status, homeless status, grade level, behavior infraction code, intervention applied, and educational services provided. And that is it.
So I have run that language by Senators Hardy and Ballant, and they're comfortable with it. Not looking for, please, Senator Lyons.
Are we going to hear from the Department of Health regarding the youth risk behavior survey? That's my first question. And because this is a significant amount of work on their behalf. Some of the work that they do is slightly different. They use, remember, they use individual survey data and self-reporting. So I don't know how this is going to fit with what they're doing.
Mm-hmm.
We'll find out. The other, and they may have other ways of collecting data that I'm less aware of. So the other question I have is where it talks about disaggregated data information. Where did it go? Uh-oh. Well, I'm wondering if what we mean is aggregated by the following groups. So if you disaggregate it, it means you may be looking at individuals. So I'm just, the goal is to have an identification of the number of Black, Hispanic, white kids. But if you say it's disaggregated, that means you're going to have some identity. So that's a question.
Yep.
We can ask them. They know the Department of Health does this all the time. And then those are the two big questions I have.
great.
right now.
And
A lot of this stuff is available, so that a lot of it won't be difficult to get.
again, we're focused on, the yellow are the changes. And I was going to have agency in, and a few other people. I did run it by some of our advocates, and those who have been working with us a little bit on this kind of thing, but just wanted to, again, put it out there. Senator Chittenden?
So I'm completely fine with this language, but similar to what Senator Lyons was just mentioning, I'm looking at the last page, page 3 of 5, item line 10. It says shall be in disaggregated format, but then it softens itself by at the end it says, and to the extent information is available. So I'm always worried with that shall, when I also remember hearing Secretary French saying the data collection can be problematic, and so he wanted as much leniency in the language. So that the shall gives me pause. But again, I yield to Jim and his expertise in how to write language like this. And the other comment I wanted to make is the re-educational. I've never heard of this term before, re-educational, but if that's a known term, then great. But I don't know if in definition, but re-educational services, that's unknown to me.
Jim, did you want to say anything about the shall or anything?
I think the shall is fine. I think you want shall here, but it is conditioned based upon privacy and availability.
Yep. Okay. Senator Perschlick?
Yeah, I'm a little confused about the cross-tabulating part. And maybe it's just because I'm not sure exactly what cross-tabulated means or what I think it is. It seems like I understand cross-tabulating when you have different data points, but you're cross-tabulating some of the same thing, like race and migration status and migration status. So
we're looking on page 4, just so everyone knows.
Yeah, so we have a list of things that need to be disaggregated. And then we have a list of that disaggregated data gets cross-tabulated by these other things, but a lot of those are the same. So I don't know if the goal is we do that so we can see which of these students have more than one of these characteristics. So you would know that they could have their race and their gender and their migrant status. That's the purpose of the cross-tabulation. Right? That's one question. And then the other point I have up in E on page 2,
Yep.
line 5, when it says compile on a school district and approved independent school basis, that makes it seem like that the data will be, I guess, compiled by school district, but not, but compiled, not disaggregated by the school district until you get down to that other section. Do you know what I mean? It seemed, I just didn't know if we're collecting the data in a disaggregated form as far as school district goes, because then down below we say disaggregated, cross-tabulated the disaggregated data by school district. So
Right.
That's my question, if it makes sense.
Yeah,
What
no,
is
go ahead.
So what's the goal? I mean, when you see the data, what do you want it to look like? That's the question. So you want to know by school district, the number of kids who are in each of these categories. You're not, and if you have a school that has one of them, that's going to be problematic.
Right. That's why it says permitted by federal and state privacy.
Right. So, but you do want to, so it, we'll just have to, the other thing is, I don't know that, well, do you want to know specifically these numbers, or is this something that if people are going to go into individual schools and gather the data, that's one thing. So the school would have that information.
Mm-hmm.
If you're asking the Department of Health to do it, they're going to do it more, as I said before, they may do it by survey. And so they'll ask the kid, are you Hispanic? What is your ethnic background or racial how do you identify racially? So they could say Hispanic or whatever. So yes, it would be important to hear from the people who are actually collecting the data to make some recommendations about how to, how they would do it. Because then that'll
Yeah.
maybe make some changes to the language,
Well,
I think.
Go ahead, Senator Pursley.
it does say it's compiling the data. So it's almost, the way I read it is that they're not creating any new data, but they're just compiling the available data that's
Right.
out there.
But are they going to put it, just let me go back. Hold on. Go ahead. I'm just looking.
No, I think the only thing, I want to add is that we've got a few days for this, a couple days for this, wanted to get it out there. I was the one who worked with drafting this, and as usual, completely open to suggestions, edits, etc. But I will line up a few people for us to hear from tomorrow. Senator Lyons.
Yeah. No, so I'm going back to powers and duties, and it
Okay.
says
What page are you on? And
on right first page.
Yep.
Right, line 8.
Yeah.
So make recommendations to end suspensions and expulsions, but all for the most serious student behaviors.
Correct.
Okay. Taking into account the Vermont Youth Risk Behavior Survey.
Correct.
Okay.
So all the language.
All right, I get it.
Voted out, save for the yellow language again, which would be the amendment. And I think there are some good questions related to this, and I think we should have AOE, ACLU, Department of Health in tomorrow to help us with this.
So
Please go ahead.
yeah, no, I'm still processing this because we've got the state's attorneys in here. And I want to ask why.
Could you just direct us to a line?
I'm sorry. Page 2, line 8.
Oh, yeah, line 18.
So,
So that would be something I think we'll probably get some feedback from the ACLU on that.
Yeah.
Yep.
Yeah. Okay.
Senator Hooker, I'm sorry, Senator Lyons, did you have something else?
No, I mean, when we go through and we look at these things, we're always looking at the very most extreme. So we're looking at civil and criminal citations,
Yeah.
which are in and of themselves sufficient for a kid to be put somewhere special or treated in a different way. I'm trying to figure out what we're trying to get at. That's all.
Yeah, and I think, a couple different things are happening here at once. It's the, disaggregating the data that I think Senator Balint and others raised, and then along the way, there were a few other edits, but we can again adjust accordingly. Senator Hooker.
Originally, the bill, I think, was intended to gather more information about Vermont and compare perhaps it to the information that's already been gathered in other places because the research shows certain things. So how do we compare with this? Are we doing better or worse than other places in the country? And the complaint, it seemed to me, was that we didn't have the kind of information that was necessary to really understand what these this type of discipline was, how much it was occurring and what it was doing, what kind of effect it would have. And with regard to the reference to state's attorneys and stuff, the idea that expulsion was directly related to an increase in juvenile juvenile activities that ended kids up in the court system, something that we wanted to take a look at. At least that's what I'm getting out of the bill. So, and I do share your concern, and I know that the secretary had talked about the disaggregation that might lead to identifying, personally identifiable information. We certainly don't want that, I don't believe, but how can we gather that information about people of color, people with disabilities, whatever, and maintain the privacy?
Yeah, as best we possibly can. Yeah.
So what we're really getting at is to characterize the kids who have been expelled or suspended in each grade by grade
Mhm.
level and then by characteristic.
Mhm.
That's what we really want to know. So then the question is, if we don't have that information in the first place, so we know that somebody's been suspended, how many years back are we going? I don't know.
Mhm.
Who has this information? It could, if it's on a record somewhere, you have a name and you have a date and you have the period of suspension. The only way you're going to know everything about these kids and all this information is if you know the kid. Just trying to figure out how we're going to get it all. That's all. Because if we look going forward, we're going to get it, because then
Yeah,
you're
and
gonna
that's
keep-
what
I
we're
think that's
talking.
Yeah.
point
Okay,
of-
we're not talking about going back. Okay.
Right. We're not talking about going back. We're just talking about
All
going
right.
forward.
I'm getting there.
Nope. That's okay. No, this is all helpful.
Although it does mention that the task force will be able to get data from AOE, the data that they have. But again, the data seems to be incomplete. So I don't think we're going to get the disaggregated points that we would like to get moving forward.
Mhm.
So, I mean, for me, I want to know the social issues and the social determinants are, for me, are so much more significant than some of the things that are listed here, frankly. Sorry.
No.
Yeah, so is there someone addicted living in their home?
Yeah.
That's a key question. Are they in a family with a single parent? That's significant.
Mhm.
Just because you're Hispanic doesn't mean you're that's not really going to be one of the, I don't think it's going to end up being one of the driving characteristics, but
Well, we hope not. You know.
Yeah,
That's what-
well,
in part what we're
anyway.
trying to find out. Yeah.
okay.
I know you've done a lot of work with ACEs, Senator
Yeah.
Lyons, and do we make reference to those types of experiences that kids have had? I mean, I don't
It's
know how
tough,
we-
it's tough to get there. The question that I just would ask the question, what is it that you want to know about these children that would help characterize them with respect to suspension and expulsion?
Well, I think, just speaking for myself, if we were to get data back that showed African Americans and students of color, members of the BIPOC community, disabled, students, ESL students, ELS students are being suspended and expelled at a higher level, then I mean that's powerful and important information.
Oh yeah, no, I don't disagree with that.
And that's I don't want to speak for Senator Balint, but I believe that was the genesis of
I absolutely don't disagree with that.
right. All right, well, we will table this until tomorrow from when we hear from more people. And again, this will likely be on the floor on Tuesday. So we have a little bit of time to work on it and see if we can move in a direction and make the amendment that everyone is comfortable with.
Yeah, so, and I think that if you look at the list, just going back to that list one more time on
Yeah.
page 3, some of these things are the things that we talk about the most, and we're doing that currently within our social environment. I guess I would want to put in here somewhere a relationship to social determinants of health. Somehow there's a link in there, and
Okay. Okay.
maybe
You-
it's too much. I'm, you
Maybe,
know,
maybe, well, think about
let
it.
some,
Think
we can
about it.
let the house do it. I'm not,
Well, think about it, it's, again, we'll return to it tomorrow and we'll, at that point, we'll hear from some folks and we'll hopefully get
okay.
more clarification and then hopefully to the point where we feel like we have some kind of agreement by Friday. If not Friday, Tuesday. Friday, actually. Anything else at this point? Okay. Thank you. Ms. Simmons, good afternoon. Welcome back to Senate Education.
Hello.
We're now shifting gears. I think this is, I've mentioned several times in the committee already, colleagues in the Senate, and I suspect other colleagues in the legislature have received emails, phone calls, outreach with information that is very concerning with regard to Kern Hatton. And Senator Ballant and Senator Lyons and Senator Sears and I met and are trying to put together a path forward to understand the situation and understand as best we possibly can to protect children, to protect potential victims, to get to the truth. There are, we know that the Agency of Education, what I, for one, am looking for today is an update on the investigation. I have, I think, some other questions as it relates to how we kind of got to where we are today with regard, and by that I mean, I know there's some back and forth around what the state board was responsible for, what the Agency of Education is responsible for, but I'll hold those questions. I think right now, just to tee it up is, and I believe I speak for everybody on this in this meeting, we have very serious concerns and look to you today, at least to start by giving us some background and some information on where the agency is in its process. So with that, we'll turn it over to you and then we'll have some questions.
Thank you. I'm Emily Simmons, General Counsel for the Agency of Education. I can provide you some background information about Kern Hatton School. Generally, I'm not sure how many of you are familiar with Kern Hatton. It's located in Westminster, Vermont. It is an approved independent school, and as this committee is familiar, the term approved has significance in our education system because that is a type of independent or private school that specifically is authorized to receive tuition funds from those towns that pay tuition rather than operating for its resident students to receive education. The other kind of independent school that receives recognition from the state are recognized independent schools. Attendance at both categories, approved or recognized, means that a student meets the requirements of not being truant, of attending a public school as was required by law between the ages of 6 and 16. But Kern Hatton is that second level approved, which is by the state education through information provided by the agency. Kern Hatton's last review of its approval status in just the regular course was May of 2017. Under the terms of that approval, it would be reviewed again in the normal course in June of 2022. So it's right at the end of its normal approval renewal. The school has 58 students at last enrollment count. 41 of those students are residents of the state of Vermont, 14 are residents of New Hampshire, and 3 are residents of New York. The school has a residential program, but not all students who receive their education at Kern Hatton also reside at the school. The breakdown there, that last enrollment count, was 47 residential students and 11 day students. So the majority of students receive education and reside at the school. has currently, and this has changed over the years, but as of last enrollment count, all students who live at and attend Kern-Hatton are in the custody of a parent or guardian rather than a state's child welfare system. Previously, the most recent number for Vermont's placements was 7 Vermont students had been placed by our Department of Families at Kern-Hatton. Then finally, is just the last demographic information is remember that because it's an approved school, students who live in school choice towns in Vermont can select to attend there and have their tuition publicly funded. Currently, 1 student uses public funding to attend Kern-Hatton. That student is a day student, not a resident. So no Vermont students are publicly funded to reside at Kern-Hatton currently. So in the fall, DCF and Kern-Hatton agreed to terminate Kern-Hatton's residential treatment license for most of its history, I believe, or at least many years. Kern-Hatton had a license to offer residential treatment to its students, which was students who had significant needs that could be met by the specialized staff at the school. That license is by DCF, not the Agency of Education. And from what the Agency of Education has been told, it was a mutual decision on DCF's review between the 2 entities that the school was not using did not have any students who were receiving residential treatment. The program had shifted over the years for whatever reason. And so the school agreed to terminate that license. But this action was the instigation of the agency's awareness about Kern-Hatton, and we received DCF's written report of the residential treatment facility and found some areas for review, some areas to, if true, that would be areas of concern with regard to compliance with the rules that apply to approved independent schools and the education statutes that just apply to all schools. So we have an ongoing Agency of Education-led investigation that takes place under State Board Rule 2222.8. The process is just laid out there. It calls for, on complaints that seem to rise to the level of investigation, the Secretary of Education appoints a review committee that will conduct the investigation. That's made up of 3 employees of the Agency of Education, and it is required to be inclusive of at least 1 member appointed by the Council of Independent Schools. That's a group of headmasters of independent schools in the state that are appointed by statute to be advisory to the Secretary of Education. They have various roles, and this is one of their jobs, to select one of their members to serve on an investigation committee when these come up. So we have 3 AOE employees and 1 independent school headmaster who are currently conducting the investigation into compliance with the laws that apply to schools generally and independent schools specifically at Kern-Hatton. That investigation has been going on now for 2 months. I'm not directly involved in the investigation. The secretary needs to have some distance and not be seen as influencing such an investigation, because when the investigation is complete, the rule calls for the secretary to determine, in the secretary's discretion, whether to recommend action to the state board, formal action against the approval standard or the license to be approved as an independent school. So we're not to that step yet. The investigation committee will submit its report to the secretary. It's at that point that the secretary will digest it and make the decision what to do next. If the secretary sees need to take action against the approval status, he will communicate that to the State Board of Education. They already have an independent attorney who will advise them, and they'll hold a formal APA hearing The parties at that hearing will be the Agency of Education and Kern-Hatton. Then finally, just to tell you, I think you're not going to be surprised to hear this coming. Because the investigation is ongoing and because we have privacy concerns with regard to students and on top of that minors, there are going to be things that unfortunately I can't tell you today. And I hope that that's not seen as stonewalling or frustrating. It is what it is. And I want to go ahead and say now so I don't forget. I do believe there is potential for an opportunity for lessons learned coming out of this experience. It's been a long time since the agency and the state board held a formal hearing about approval status. So please invite me back when this matter will conclude. We will close it out, and there will be more that we can share with you at that time. And I would love to be invited back to share with you any lessons learned and implications for statute changes if there are any.
Thank you. It's very helpful. If I could just start off, can you tell us a little bit, your investigation was because of complaints. Can you just tell us the number of complaints that the agency has received?
In this instance, the investigation was actually because of the DCF report.
Okay.
At the same time, I believe just public awareness increased. There was a news report about DCF's action that could have been the impetus. I'm not really sure. So we have received many complaints regarding Kern-Hatton since the investigation had been contemplated and opened, but the actual impetus was not a sort of constituent or student or family complaint. It was the action by DCF. So I don't have the count of the number of complaints. They are all being received in one place by our investigation committee. They're all being cataloged in one place.
Senator Lyons.
When will the investigation end? You said it's been going on for 2 months and there'll be a report forthcoming. Is there a timeline that you can share with us for that?
Yes, the original end date for the investigation, the secretary asked the committee, he gave the committee its charge and asked for them to either wrap up by February 15th or to communicate to him causes that more time was necessary. So the committee did that relatively quickly. They have communicated to me in advance of my testimony, because we anticipated you would want to know, that they are concluding. I don't want to pin them in by giving an exact time, but it's been ongoing 2 months. I don't think we're going on another full month from my updates that I've received from the committee.
Okay, that's helpful. As Senator Campion, Chair Campion has indicated, we are planning a joint meeting with Judiciary and Health and Welfare next week. And so I might ask you to keep your schedule clear Wednesday morning so that we might have you inform the 3 committees as you have today. It's very helpful. Thanks. If that's okay with Senator Campion.
Absolutely. As Senator Lyons mentioned, and we've talked about, this was Senator Lyons and Senator Sears, Senator Ballin and I thought it would be a good way to start with a conversation today. We had some questions around education and our role in understanding this and what the administration is doing, and then move forward on Wednesday. Senator Hooker.
Thank you. Ms. Simmons, you mentioned that this investigation was prompted, I believe, by the report from DCF. Am I?
Yes.
Getting that? Okay. And can you tell me what kind of, when was that report initiated? When was the, what caused that report? Was this something that DCF has had? Is this something that, they were looking into to see whether or not they were going to take away their the license, or that the school was going to not have its treatment license anymore. And I think you said that it was a mutual agreement that the school would be relieved of that license because they weren't using it. Is that what the report is based on?
Senator Hooker, I'm not briefed in on the causes or lack of causes. I think that's a great question for DCF. They, as a courtesy, shared the report with the agency since this is an approved independent school. And there was concerning information there. I think they felt it was their duty to share it. It very well could have been a routine licensing report. I wouldn't venture to answer whether it was routine or otherwise.
Okay, thank you.
So if I may, if there was concerning information in a DCF report, why would the Agency of Education not just shut programs down across the board instead of continuing?
It's a really good question. There's not authority for the agency or the state board to take, I think, what would commonly be called emergency action against an approved school. I looked in our statutes and our rules expecting to find that, because in other areas, for instance, with licensed professional educators, the secretary does have that kind of emergency authority to go forward and have a hearing after the fact, have due process come after revocation. And that does not appear with regard to approved independent schools in current law.
So, I'm sorry, my volume isn't working. This is just for my own clarification. So no one asked for the legislature to quickly approve a bill that would allow for emergency action. That's correct.
That's correct.
Okay. And that emergency action, since we don't have it, that does not allow the Agency of Education to go in and shut down a program, even if the Agency of Education is concerned with what might be happening in that program.
Right. And that's correct. And that's with regard to the school holding the status of approved, which means that students can take public tuition there. That's AOE's lane. And no, we did not reach out asking for a change to statute.
Because I know when, and this is not apples to apples, but I know that when we had a situation down here with polluting of groundwater, people came forward to the legislature with requests for legislation to allow agencies and the administration to act in certain ways which would benefit and protect Vermonters. And that was not taken. There has been no request at this point for emergency action.
Correct. And
Okay.
I'm not implying that the agency has found facts on the ground
I
that
understand.
would, if we had that authority, lead us to invoke it. And for everyone's peace of mind, because I feel my own heart rate accelerate when we think about students who, imagine another hypothetical situation who are in danger, and you're imagining that the agency can't do anything and hasn't asked for that to be changed. There are other players with their own jurisdiction. So there is DCS Child Protection Division, who have the job of investigating child abuse and neglect. This is parallel to the agency's authority and the state board's authority to oversee compliance with approved independent schools. And then in many cases, the worst cases, you also have criminal behavior, of course, that the police would have jurisdiction over.
Thank you. Senator Pershing.
Thank you, Chair. Ms. Simmons, my interest in this is what I read in the press regarding the AOE asking the Board of Ed to do it, and the Board of Ed saying, no, we can't do it, you do it. And I guess my question is, I didn't see anything back from AOE saying, I assumed after the board said, no, we can't do it, you do it. AOE said, yeah, I guess you're right, we got to do it. I wonder
That's
if
correct.
it's agreed. So you agreed with the board's analysis that they didn't have the authority, even though you asked them to do it.
There's, and I believe the state board is going to bring this up on their own, but I know about it, so I'll bring it up. There are two ways the state board can enter into compliance enforcement questions of the independent school standards. One is older and is the one we're using and was not put into law recently. It's in the state board's rules and has been for several revisions. It's where the secretary conducts the investigation through this committee and makes a formal recommendation that triggers a state board hearing. The other kind was put in law in 2018 in Act 173 and has been used a good bit or 2 times since 2018. That's with regard to financial non-compliance, just to put it very generally. And there, rather than the agency being the first actor, the state board goes first and appoints its own review committee to investigate the financial issues, and state board members are on the review committee. And it's everyone's opinion that the 2018 changes, giving the state board this new review authority with regard to financial matters, does not jive, and we probably should have looked more closely at what was already in the state board rules, does not jive with the pre-existing process where if there's a complaint or a concern, the agency investigates. And the board sits in a quasi-judicial capacity where they are neutral. Obviously, where the board has investigated financial issues as the investigating entity, it cannot then also serve as a neutral quasi-judicial, right? They've been involved, they're no longer neutral. So there is a need, and it has been discussed at the state board, at least in their rulemaking committee, that there's a need to bring those two provisions into harmony with a legislative change, because it's not cohesive practice and will get us into a bind. So here, the questions with Kern-Hatton first seemed like they were going to be taken up as financial questions, and the state board was fresh off of a process where it had looked into another approved independent school's financial questions. So that process was right there in the back of everybody's mind, very familiar, and it's what we all jumped right into. I'm very grateful that we got onto the more appropriate track that we're on now. And I think I can say all parties are comfortable that this is the appropriate process for these facts.
And so I hear in that either you guys or the board will be coming forward with a request to make that change to harmonize those two?
Yes, I am the draftsperson for a state board committee that's looking at changes to the relevant rule series. And those committee members they've talked about coming to you for that change.
And do you remember last year when we split, we tried to make it a difference in what the board does and what AOE does. And we had that whole list of the two different things that didn't pass because of COVID. So I hope we can get back to that at some point, Mr. Chair. But with this wouldn't have helped, and that, like, what we did in that had no impact on this policy you're talking about.
The draft of that bill that passed the Senate would not have made that clarification. The version of that change that the agency would have kept pushing hard for, I know you got sick of hearing me pushing for that last year, would have done away with the conflict.
Right.
In our preferred organization, it wouldn't be an issue. Yeah.
Right. Okay. Thank you.
So just to go back here for a moment. So Senator Perchlik was asking about the back and forth between who's responsible. Was it the state board or the agency itself to do this investigation? So DCF came out with a report that the Agency of Education believed to have concerning information in it. And then what did the agency do next once seeing that?
We shared it with the State Board of Education.
The State Board of Education. So where, and I'm just trying to get why did everyone think that this was a financial matter? And maybe I'm confused. Why did, please go ahead.
I was working, this was totally in my my email flow, my phone call flow at the time, and I was working with the State Board of Education's chair. And, the concern was on concern for students and appropriate oversight and swift action. So the State Board discussed taking, the appropriate steps and following the right process with regard to Kern-Hatton in 2 meetings. I believe they were the October and November State Board meetings in 2020. So all of that meeting footage is out there to discuss or to view, I'm sorry. And then the State Board and the agency totally agreed and supported them, reached out to their independent attorney who they sometimes work with when, they need their own independent counsel. And that individual very helpfully stepped back, reviewed everything, prepared a memo for the State Board. And from there, the State Board was totally clear and communicated to the agency, here's the rule, this is your job. We ought not, and it would not be appropriate for us to be involved because we will later need to be the quasi-judicial body deciding this. And from there on, things have been very smoothly on the tracks to the present day. But there was, I guess you could characterize us as both carrying the ball and being supportive of each other carrying the ball. That seems like a good process, but was not the right process under the rule. I still feel like I didn't answer your question. I'm sorry.
For me, it's interesting. I was in the legislature when we started to streamline, if you will, the State Board and Agency of Education. And it's just concerning to me I think we need to come back to that possibly. I mean, as we're looking at lessons learned and what can we do, to have a back and forth around, who's responsible for a situation that's so serious. There just, and I know you would agree, there just should be no debate. There should be no discussion. How again, and do we move forward and take some of the lessons learned and avoid that kind of thing in the future. Other questions?
I guess, yeah, I think along those lines, Emily, do you know when the board rules were last sort of re-upped, improved, changed, looked at? Do you have, and particularly the rules that you're talking about today?
The current rules were last put through rulemaking in either 2013 or 2014. Maybe they were finalized in 2014.
Mm-hmm.
They, luckily, I think to your question, they will be open later this summer. The act that I've mentioned a couple of times, Act 173, requires rulemaking with regard to the approval of independent schools. And the committee that is composed of State Board members that I'm working with already has some consensus language between the independent schools, the public schools, the agency, that adds what we all think, and it's our work, so of course we're proud of it, adds a much more clear process that would govern the agency's intake of any kind of complaint about an independent school and investigation process. It adds the ability to use probation as a outcome. Right now, the agency can recommend revocation or suspension of approval. And so the idea is that a middle step would be helpful in many instances. So the rules have not been updated for many years. It is long overdue with regard to lots of issues. This is one of them. And we've already seen good progress that will be filed with ICAR in June, I believe.
Okay, well, it looks like fun for LCAR coming up, and that's a good thing. But the other question I have about the rules is the relationship that you have with DCF as you're writing these rules. Obviously, there's some link there uh, with DCF and the Child Protection Division, and whether or not the rules that are there are also in sync with the rules that you're putting in. I mean, certainly would make sense to have some cross-reference in some way, at least notice provisions within the rules for DCF and vice versa. And I don't know whether you've considered that.
It's good advice. We have a little bit about DCF, but it probably does not go to your good point. Right now, the rules require the agency's investigative team to refer suspected abuse or neglect to DCF to make a report. We're required to do that anyway. That's not much. We could, we'll run them by DCF as a stakeholder. And yeah, I think we could put something in. It's good advice.
Yeah, I mean, I just think keeping each other informed in a situation like this is would be extremely helpful. And I think as we go through the testimony next week, that will, this will make more sense to all of us. But thank you.
And if I could add one thing, and you could probably hear more about this next week. AOE and DCF have a memorandum of understanding that results in the Agency of Education receiving the reports of allegations to DCF that take place in an educational setting. And our AOE investigator reviews those on a daily basis.
So as soon as that report came in, it was reviewed by AOE.
Correct.
On a daily basis. Can you say something about, I'm sorry, Senator Lyons, did you have a follow-up? Would you mind telling us a little bit about what these investigations generally entail? I mean, interviews, site visits, just tell a little bit about the process.
Sure. So one thing that I can share about the secretary's charge, the investigation committee, it's a matter of public record. Two main issues, and these were not limitations, but two starting places for the committee were around what appeared to be a pattern of failure to report allegations of abuse and neglect at the school to DCF. So we found that very concerning and said, please have your investigation cover this topic. And also some reason to believe that the background checks statute had not been consistently followed. It seemed that there might be some missing background checks for employees. So I'll make very clear, we do not know the outcome of that. That will be in the report that's forthcoming. But the report is being written by the committee of 4 people. The investigative work is conducted by our AOE investigator. His name is Robert Stafford. He is a very experienced former law enforcement official, chief of police, leader of the New Hampshire Police Training Academy. His credentials are a real value to the agency when we do have to conduct this kind of investigation. They're conducting primarily interviews with former students or current students and their families, and with the school's administration. The agency has requested voluminous documentation from the school, its own records about students, about complaints by students, and about the school staff and their credentials and background. And as I mentioned earlier, I have an arm's length. I'm not involved in the investigation committee. I just have been overseeing their progress to make sure that things keep moving. That's what I know about. And I believe the best investigative tool is probably the interviews.
That's very helpful. Thank you. When DCF, again, put out the report and said that, identified that there was disturbing information in that report, you mentioned that law enforcement, others could have gotten involved at that point. What's usually the process? I mean, again, they haven't gotten involved. Is that accurate?
No, I did not say that. I do not know whether they are involved.
That's what I'm asking. Okay, so you don't know if law enforcement, it's possible that law enforcement has been involved, but we do know that the school is still, save for the one part, the residential treatment, the school itself is up and running. Children are going there every day. Okay, Senator Lyons.
Yeah, so, and along those lines, I'm glad we're getting into some of this detail. And I'm glad that you brought up the background checks and the employee information. It sounds like there was a real gap there. There may have been a gap there.
We do not know yet. We're
Okay,
investigating whether there is a gap.
So while the school is still in operation and the investigation is going on, obviously, people may be more alert to or more careful to avoid scrutiny on some of these things. What kind of protections have been put in place to ensure that some of the events that we're probably going to hear about going forward, some of these events are being mitigated? How are we protecting kids? I guess very simply, what's going on to protect the kids right now that's different from before this investigation started?
It's a really good question. So I hope that nothing I said has led you to conclude that those things are not in place, right? I just feel the need to address a little bit of an elephant in the room. The fact that students are there, law enforcement has their own jurisdiction, DCF has their own jurisdiction, is a comfort to me, because if ongoing, for instance, let's take DCF, if ongoing complaints of abuse or neglect are made or student reports are made, it is perfectly appropriate to assume and to ask DCF, those are being handled in the normal course and investigated in the normal course. The AOE investigation has not stymied or stopped the other agency's jurisdiction at all, which I think is very important. We all have to do all of our work at the same time together. So what's being done to protect students now, I think the increased scrutiny is a positive step. It can give all of us some assurance that there are many eyes on operations at the school currently that had not been there before the investigation started. The investigation is in no way preventing the school from improving oversight, improving compliance. The investigation committee has told me that some of the concluding work is in reviewing new, I'll call them policies very generally because I'm not sure, that the school's administration is considering and putting into place. That's very encouraging to me. It seems that we can expect the report to identify some changes that have been made since the DCF report. I don't have other answers for you as to what steps are new steps that weren't in place before the investigation, because again, I'm speaking about AOE's role in our jurisdiction, which is to conduct the investigation, which will allow us to formulate a recommendation to the state board.
Okay, thank you very much. Yeah, so for us, I think this is a beginning. I actually look forward to hearing more next week, so I appreciate everything you've brought to us.
Can you just say, just following up on Senator Lyons' question, can you say what you mean by there are more eyes on things? I mean, do you have members of the Agency of Education there? Are there, can you just say what that means? Clarify that a little bit.
Yes, I mean, the members of our investigation committee are actively interfacing with the school, with its staff and its administration and its legal counsel. And you can also, I know that you'll ask DCF. My sense as working in a sister agency is that the same can be said of DCF, that they have staff who are also there to support and ensure that they're following their jurisdiction with regard to the school.
Sort of like they're coming in, they're there.
I don't think, no one's there. This is all
No one's there.
communication. No one has made a site visit to Kern Hatton. This is document review. This is interviews. It's because our review is of compliance with the law. And there aren't questions about, for instance, the physical facilities that I'm aware of. And if there were, that would necessitate a site visit.
Are there questions about the staff?
I don't think I can answer that.
Okay, so what I'm wondering is if DCF put out a report that was concerning, and you mentioned that there are more eyes on things, does that mean that there are more eyes, in terms of protecting children right now? Are there agency folks there? Do you know if there are DCF folks there to make sure that children are safe?
There are no agency of employees at Kern Hatton, no.
Okay. Senator Hooker.
And I don't see a need for that. I'll defend this a little bit, what I know about it.
Please.
I don't have a concern about things happening at the school that an agency of employees' presence is necessary to step in physically.
That's helpful. Thank you very much. Senator Hooker.
I'm sorry, and maybe you've said this before, but when was this report shared with AOE, and how much time was there between the sharing of the report and the beginning of the investigation?
There were 3 months between the two.
And do you have any idea of the population or the enrollment down at the school? I mean, I thought I read that they're capable of housing like 100 students, and I believe you said that there were about 50 now.
Yes, enrollment at the school is down by, I think, half. Their last approval, which is in effect now, they can have up to 100 students, or a little over 100 students.
Mm-hmm. Okay, and do you know how long it's been since they had, that peak?
I don't have year by year enrollment information. The information I have, I got in November for the state board, or not, in October for the state board.
Okay, thank you.
Ms. Simmons, can you give us a sense of when the agency communicated with families? If you have a child that goes to Kern Hatton, at what point was there a communication from either the agency or DCF that said, there's an investigation, part of our program has been shut down, we are concerned, anything like that?
I don't know what communication DCF is required to send about that license. The Agency of Education has not communicated with parents. I believe it would be inappropriate to do so before our investigation is complete. We would do so if it were in the rules. There's not that requirement to do so in the rules, and we don't. Right, we have some questions that we've asked, and the answers are pending.
Other questions? Ms. Simmons, please.
If I could, I want to avoid any confusion. If just jump down the road, and I'm not implying this will happen, if the state board ultimately took away the approval status of Kern Hatton or any school, there's a limited meaning to that action. It means that no student may use publicly funded tuition to attend. It does not impact a family's ability to send their child to that school. And
Would you
I
repeat
think
that
just
last part?
yeah. So if a school loses its approval status, what it
Yeah.
loses is the ability to receive school district funded tuition for students that attend. It does not lose its ability to enroll students who pay privately or whose attendance is supported through charitable funds or otherwise. The agency, just that's a statement of the agency and the state board's jurisdiction. That's the legal authority we have to give or to take back the approval status.
Does the agency believe that the children that are there now are safe?
Yes, I feel the need to say, yes, we do, because of the systems that are in place. But please note that the investigation has not come back. I've not seen a preview of it or anything like that. So put together these things, that the Department of Children and Families takes the intake of any complaints, allegations of abuse or neglect, and shares those with the Agency of Education, but those are confidential. That agency, we all know, is aware of Kern Hatton because they wrote the report that got my agency involved. And then also that law enforcement has the duty, the jurisdiction to investigate any crimes that are suspected at a school. So all of that together allows me to say that we are in a place where we will have answers soon, and there very well need to be steps taken. But we will not know until we have that investigation. And I trust that other agencies are fulfilling their responsibilities to students as we are at AOE.
In this kind of situation, who could shut down a school or an institution if there were complaints of abuse, if there were complaints of anything? If students were in danger, who does have the authority to go in and say, this institution is going to close in the state of Vermont until further notice, and the students are going to be redirected to other educational opportunities?
So to shut down and to...
In the interest of the safety of children.
I do not believe any state agency has that unilateral authority.
Okay.
The others, the students from out of state, I feel a very strong responsibility to the students from out of state, because Vermont has this term approval, and I know what it means. We know in Vermont what it means because it serves our very almost totally unique Vermont purpose related to tuition. Other states like New York and New Hampshire don't have that term approved in the same way that we do. And I don't know what it means to a parent who sees on a website that a school is approved by the Agency of Education, or by the State Board of Education. I take very seriously that they might read more into it than we legally mean. And that motivates us at AOE to ensure that there is full compliance with all of our requirements of approved independent schools, because it means this, almost nuanced thing about tuition in Vermont, but it carries a lot of weight if a school is approved by the state of Vermont.
Kind of the seal of Vermont, a seal of quality, and the perception that everyone is much healthier in our state. So when something goes bad, it really does put a blemish on who we are culturally. Yeah, I get it. We get it. I'm glad you feel that way. I'm glad you feel that it's important to protect that approval.
Senator Hooker.
Did the courts shut down the school?
I'm not that kind of lawyer. I feel so ignorant right now. I'm sorry, Senator Hooker. Probably so.
I'm just curious.
Right. And there can be civil actions brought by individuals and additional criminal actions. I'm so sorry. I have such tunnel vision for my statutes and my areas of law sometimes. Yes.
So I will say that when we take this up again in a joint setting, we'll have other ledge counsel there who have experience in this area. So we'll be, and we'll have other, maybe there'll be some outside counsel folks who have had experience with this and can answer some of these questions. And if they can't, we can find someone who can.
Please, Ms. Simmons.
And I feel like I'm leading you down a path a little bit, and I don't mean to be. There are several developments that are in the works that are exciting that I think you would want to know about. One other is the same state board committee that is looking at these same rules that I've told you about that opened this summer. Also has decided, although nothing is formal yet, their ongoing work has decided that there ought to be more standards in the approval rules related to residential programs. And so the lever that committee favors is related to NEASC. Are you familiar with NEASC that accredits elementary, high schools, and post-secondary? Yes. So many of our Vermont approved independent schools are NEASC accredited, and the state board NEASC accreditation as meeting many of the approval standards without a secondary review. NEASC can stand in for a lot of the approval process because it's very rigorous, or believed to be very rigorous. NEASC also reviews schools that have a boarding program, a residential element. And so if adopted as final, this new state board rule would require any approved independent school that has a boarding component to have NEASC accreditation, so that organization, which is very experienced in conducting that kind of regular review, would have its stamp of approval on the program before the state board considered approval.
Any other questions for Ms. Simmons? This was intended, for a first look, if you will, start some testimony, which, as you know, Senator Lyons mentioned, will continue next week. And I want to thank you for being here. That what you've shared has been very, very helpful, very thoughtful testimony. Appreciate your concern and your commitment. And unless there are other questions, or if Ms. Simmons, you have final comments that you would like to share with us, we will look forward to continuing to work with you on this.
Thanks for your attention to this as well.
Thank you. Okay, committee. Thanks for a long afternoon. Jeannie and I are going to stick around and work on the agenda a little bit, but a lot of work. Thank you. I hope everybody can Zoom off right now and get outside. Thanks.